Okay. Morning, ma'am. Ma'am, please allow. My lord, I beg to mention item number 5 to 9, my lord. Yes. Yesterday we have filed our affidavit, my. Okay. So additional affidavit. Additional affidavit to come, my lord, along with the affidavit any other day, your lord. Okay, right. Item 5 to 9. Mr. Jay Borguya submit that additional affidavit has been filed. Yes, sir. On behalf of the petitioner yesterday. Accordingly, this is matter after the meeting. Along with the affidavit. Along with the additional affidavit. Have you have not
Yes,
served?
yes, I have some.
If you do not serve, cannot be filed. Correct. Cannot be filed.
If I do not serve my lord, I cannot file my. In office, you go and check. Back to the back to the but I beg to mention for lifting of an IM matter or impeachment matter. Your lordship may remember day before yesterday. Day before yesterday, one matter, my lord, regarding forest protection matter.
That is enough.
My lord, tomorrow, my lord.
Tomorrow, defeat them.
But I am from Hatar district, my lord, because of this, my lord, from Marke, my lord, I am going to.
You tell the government advocate to
Yes,
be here.
yes.
Government Nizam government.
Yes.
Payment of? Bill. Okay, Monday.
But I am taking listing one. This matter in last week was posted on 26/8/2022. Thereafter, it has not been received.
22.
22/6/2020.
What is the matter about?
Non-payment of contractual fee.
After the give it.
And one more clear yellow. Item 1. The order has already been supplied here.
Okay, just a bit. Item that new one you give it. And this item 1, you write Mr.
PM Khan.
A.M. Khan, learned counsel for the petitioner, submits that the order dated 22/12/2020, passed in 1735 of 2019, has been complied with. Accordingly, the contempt petition stands closed.
May I please, Your Lordship? Your Lordship, as regards item 10, Your Lordship, wrong record has been come here.
Okay, right. Mr. T. Dury, no, Mr.
Yes, Dekha, Your Lordship.
DS Dekha, submit that the records that have come pertaining to serial number 10 of the cause list is not WPC 7369 of 2020. Accordingly, the registry to list the proper, the correct case on
Your Lordship, after seeing it,
after the review begins.
much obliged, Your Lordship.
May I please, Your Lordship? But it was back to mention item number 3 and 4.
Yes.
This method, I may be allowed to withdraw matter quickly, but.
Okay, item 3 and 4.
Yes, sir.
Okay, right, Mr.
It's a PH format.
P.
PH format.
Who are appearing on behalf of
Mr. P. Bora.
Mr. P.
Miss
Bora,
Bora.
learned counsel for the
Miss P. Bora.
Miss P. Bora, for Miss P. Bora, learned counsel for the petitioner says that he may be allowed to, based upon instructions that he may be allowed to withdraw the writ petition with liberty to file a petition. The prayer of the petitioner's counsel is allowed, writ petition is dismissed and withdrawn, with liberty of petition.
Obliged. With regard to item number 31.
31, yes,
We have filed an additional affidavit that may be called for.
okay.
May please, Your Lordship. But we mention for listing of the matter.
New matter, old matter, what?
Lordship, 2019 matter.
2019 matter regarding what?
Lordship, regarding demolition of.
Huh?
The opposite party is the DMC, Lordship.
Termination of service,
No, Lordship, regarding demolition of structure.
demolition of a structure. Has it been demolished?
Lordship,
Not demolished.
I just read the last paper, it's been mentioned that there is an apprehension. 2019 matter. What's the urgency?
This matter has not
After
come up
Bihu.
for
Huh?
this matter has not come up for a long time.
Bench 5 matter. Bench 5 matter. Demolition. Bench 5 matter. This is bench 4. Yes, madam.
Yes, yes, Lord. So I want to mention regarding listing of an IA Monday, I for correction in the cost side. Which was
Correction in the
disposed of-
fourth title.
which was disposed of by honorable.
Correction in the first title. After disposal. And you mean amendment?
Yes, sir.
They have to be restored first, I think, yes. That case will have to be restored first.
Yeah.
How can we correct the disposal of matter? Everything will have to be changed, even the order will have to be changed. We will have to recall the earlier order maybe, but it's then, it's not so, it's only have to be restored. Or review. Due to a correction to be made in the text.
I may be allowed to do it, right?
Why?
If that asked to produce some budget provision like that, but yet I could not produce. And direction was to pay the petitioner outstanding dues as point budget are received by the irrigation fund. That was the query by but I could not produce
You
the
couldn't produce what?
budget provision. Budget available or not, my lord. That was the query matter. Look, it should notice and
Right. Heard, Mr.
take care.
A.K. Ahmed.
Azad.
Huh? Azad.
Yes, sir.
Then counsel for the petitioner who submit that the order dated 16/11/22 passed in WPC 6818 of 2021 has not been complied with. Issue notice returnable in 4 weeks. Petitioner will take steps for service of notice upon the respondents by registered post with AD within 3 days. This is the matter of proposal.
Avlak.
They're not here. No one appears for the petitioner. I'm sorry. This is matter after review. Same. Same. Huh? After some time. After some time. Heard, Mr.
M. Madam.
M. Sakya Learned Counsel for the applicant who says that the opposite party number 8 and 9 may be impeded as respondents number 8 and 9 in the writ petition. Yes. Mr. M. Ketya appearing for
I know.
one four five. Submit there. Yes, Mr. Datta, you're there. You are appearing for whom? 145 and Mr. S. Datta appearing for 2. 2, that's all. For about 6, 7. Who is for the PWD? And Mr. P. Chowdhury for respondent number? 3 and 5. Submit that they have got no objection to the prayer made by the petitioner, applicant's counsel. Accordingly, the respondent number 8 and 9, and the opposite party number 8 and 9. That is not this put it here, opposite party, okay? Are implemented as respondents number 8 and 9. Applicant to submit a corrected copy of the cost title for the registry within a week. Within a week, within 5 days. Within 5 days. I dispose of accordingly. Then in the main case, you write, in view of the order dated 4/4/2024, passed in IA number T563 of 2024, the this 8 and 9, this the names are implemented as respondents number 8 and 9. Who accepts notice on behalf of them? Senior electrical inspector and chief electrical inspector.
Hello, advocate.
Huh?
Government advocate will payment.
Okay. Issue notice to the respondent number 8 and 9. Mr. M. Chettiar. No, cannot be 7 and 8. 7 is chartered electrical safety engine. The Mr. M. Chettiar accepts notice on behalf of the respondent, newly implemented respondent number 8 and 9. List the matter after 3 weeks. 4 weeks to enable them to pay the instruction and file affidavit.
Hello, my name may be reflected against the petitioner in main case.
In the main case, you write his name, Mr.
And second.
M. Sakya appears for the petition.
Apply.
In 17. Item 17. Is there? Yes, who's for the for the water? Yeah, for the water resource department. Where is that? Miss A. Loda. Yes, yeah. Okay, right, Mr.
Page 4.
Page cover. Learned counsel for the applicant. Praise that the Union of India, represented by the Commissioner, Ministry of Jal Shakti, Department of Water Resources, River Development, and Ganga Rejuvenation, New Delhi, dash 110001. Should be implemented as respondent number 5. The prayer of the petitioner's counsel, applicant's counsel is allowed. Who is for the CGC? Is allowed. Is if the Union of India is implemented as respondent number 5. The applicant shall accordingly submit a corrected copy of the cost title before the registry within 5 days, within 3 days. The IA is accordingly disposed of. Then you write in the main case, in view of the order dated 4/4/2024, passed in IAC number 823 of 2024, the Union of India, represented by Census is implemented as respondent number 5. Issue notice to the respondent number 5. Mr. P.S. Bhattacharya, CGC, accept notice on behalf of the newly implemented respondent number 5. List the matter after the vacation to enable the respondent's counsel to obtain instructions in them. Detail. No need detail. Acha, Miss Loda, you're here. Acha, Miss Loda, you have no objection, I think, in that IA, you write Miss A. Loda, appearing for the respondents number 1 to 4. Submit that she has got no objection to the IA being allowed. Then, in the main case, you write, you're not filing any affidavit, I think. Then in the main case, you write the Miss A. Loda and Mr. Filso that are granted 3 weeks time for pre-inspection and find affidavit if necessary. This is the matter of the case.
16 and 19.
Item number 12, my lord.
Sorry, gone, finished. Too late.
Most normal.
Yeah,
I
miss
have
the
been
bus.
late
The-
input number 1, my
The
lord.
bus is in Christian Basti now. You have got to run there.
But after the last, as a last one.
Okay, just a minute. Item 12.
12, my lord.
Yes. Where is the admission? Item 12. Where is the admission by the state government?
Yes, my lord. Here, my lord, only that,
Just a minute, Mr. Gaur, just sit down.
here, my lord, only they have sealed the, sealed the, my lord, principal and the superintendent of the.
Where is the admission by the government that they owe you this much?
This, my lord, contract order was published by the, my lord,
I'm not,
GNC, my lord.
I'm not who issued the contract order. You see, this writ court can only pass a direction when there is an admission by the government with regard to your claim that yes, we owe the petitioner this much amount of money. Where is that admission?
But they have not received any letter, my lord. Just, my lord, or invoices, my lord, submitted, my lord, by me, my lord.
That is what I'm saying.
Yes.
So where is the admission?
Supply works only, my lord.
So you go file a money suit then.
Because 1,06,000 only.
Huh?
1,06,000 rupees.
Maybe, but where is
Yes.
the admission?
But they have received only, and they have only received that, my lord, that yes, we have already, we are to pay you. Because it is all on papers, everything are there, my lord. Only instruction maybe, my lord, thereafter, my lord, possibly they will pay. They are admitting that we have not received the fund, so we cannot be able to. But it's supply items, my lord.
Where have they said that they have not received funds and that they cannot pay because of that? Where have they said that?
Yes, my lord. I have mentioned here, my lord. Yes, my lord. That is paragraph 6, page 6.
But what have you said?
Yes, under the appropriate petitioner has approached before the concerned principal girls superintendent, hospital various representations out of them dated so 24/4/23, 26/12/23, 2/3/24, all declarants of bill amount addressed to the principal council
That is nothing. That is
Uh,
your.
which
you
are
can-
duly received by him.
You
But
can say anything in your petition.
no, no, but till date it has not been attended by, rather his attitude towards the petitioner is most mechanical one without any sign of promptness.
You
my
have
lord.
got to file an affidavit, additional affidavit, showing the admission. Otherwise, we cannot take it up.
Then I'll file additional. My lord, then file one additional epi.
Right, in item 12, right? Mr. H. Das, learned counsel for the petitioner, submit that the respondents have not paid their contractual liability of rupees 106
Yes, my lord. 255.
330
1,06,255 on.
255. Good stuff. However, there is nothing in the writ petition to show that the respondents have admitted their liability towards the said amount. Accordingly, the petitioner shall submit an additional affidavit showing that the respondents have admitted their liability towards the said amount. This is a matter after 2 weeks.
Lordship, by filing this IA, I beg to submit that response number 5 with the public statement as well as with the superintendent in regard education service. In the interest of justice, it should be increased finding.
Why?
Because there are allegations that prima facie so strong against him.
What is so strong against it?
Because Lordship,
In the writ petition,
Lordship already noticed that
just show me the mistake.
WPC 641,
Just a minute. Just a minute. Where's the prayer? Page 8. Yes.
Ever. To stop the tender, including allotment of the work, and if allotted, that to be stopped, and has been allotted.
Lordship, notice was served already by the Chief Honorable Court.
Was there any stay?
No, notice was served by the Honorable Court to the board, to the government, to the respondent parties to file counter. Counter petition is being filed. How can now this is going on? Counter petition only filed by the parties, respondent party, opposite party. Now we cannot stop the matter.
What of the? Look, Mr. Council, this is a contract matter. Now, there's already 75% has been done. Now, what is your challenge? What is the ground of challenge?
Now the penalty malafide is not there. The tender clause has been manipulated in the interest of the private Rule 7.
Tender clause has been manipulated.
And that is therefore this
Which
honorable
tender
court,
clause has been manipulated?
this honorable court passed an order dated 4th of August 2023, directing the respondent parties to file their counter request. Counter is being filed. And another tender matter, W641, that is not being filed. In this process, we cannot say there is no malafide because already court has admitted.
Mr. Council, whether it's malafide or not, will be decided by me, not by you. Please keep it in mind.
But-
You are not the authority to decide. So you are submitting. So I am asking the question. Please answer my question. What is the clause that has been changed?
Because
Yeah.
clause was that the clause to be 30% of existing similar nature work, he made it 80%. 80% is first tender. After 1 month, same tender, he came down to 30%, at 50% below. That is the issue.
Show me the,
Please see the order, WPC
show me the NIT.
NIT dated page 12. Page 12. And page 21. That is separate. Malafide
He participated in the tender process.
lordship. The
Huh?
fact is,
He did not participate in the tender process.
no. Why I'm not participating? Because tender clause has been manipulated. That is the issue. Please go to that page 21.
What,
Yes, yes.
which clause has been manipulated?
Lordship, actually, this is the I'm just giving you. This page 23, extreme below. The bidder contractors should have at least one
Page
single.
23.
Yes.
Page 23.
Of the restriction 418.
Yes.
Extreme below, Lordship. The bidder contractor should have at least one single work order of similar nature, not earlier than 3 years of value, not less than 80% of the NIT value, with 100% work completion certificate. It should be 30%. It's not 80% because there is another tender NS which is here. 15 years as a guideline that cadence.
So you want this 80% to be 30%?
Yes. 80% is made just to accommodate the particular bidder. Therefore, they are the single bidder because other.
Now, have you made a challenge to this clause?
Yes, Lordship.
Where?
Yes, Lordship, order may kindly.
No. Huh?
Yes, please kindly see the order WPC 4185 passed on 4/8/2020.
4/8.
4/8/2020. This is the order. This is the order.
4/8. No, it's here. I don't need out that. No need. Yes. 80% of the work earlier or 30%.
That will be 30%, that's the accommodation of it.
That is his allegation. So why suddenly 80%? But where is why do you want to implead this person in his private capacity?
Because in the first tender, dated 15/6/2020, he has made it 80%. Other tender of what is it 5 crores, that is 15/7/2020, within 1 month, he has come down to 30%, 50% below.
Okay.
That is 6,431. Is it a synopsis of the 6,431? Very interesting. Synopsis of the 6,431.
640, this is it.
Synopsis of the 6,431.
Right. This is an application for impleadment. Any objection on your part? He's a private person. You've got nothing to say. Right. Right, Mr.
PK Bhattacharya.
AK
PK Bhattacharya.
PK Bhattacharya. Petitioner in person. Who phrase that? The American is it? And poster. This who is the person?
He is a supervising engineer. Dr. May,
Where
I,
is his name?
yes, in Dr. May, kindly see the page 17 of the IA. There is an order of the Honorable Guwahati High Court.
No. Who is this person that you want to implead by name?
He is the superintending engineer to have
Where is his name?
Kolin Kumar Bhatt.
Where is it?
No,
In your petition.
Still now not impeded because therefore I want to be impeded by name. The liberty is done.
That's why you have to put it here.
Okay, initially I filed the case against the post. On considering the gravity of the matter and considering the nulla factis alleged against him,
Mr. Counsel. No, they are not even a counsel, sorry. Mr. Petitioner, to implead a person by name, that person's name has to be recorded here in your application.
Dr. kindly see page 17 of the I.
17 of the I.
That is the order of the Honorable Deputy
Mr. Counsel, I know, Mr. Petitioner, I know this. This is not, you see, there is a certain procedure to be followed.
I beg your pardon.
Okay.
I beg your pardon.
If a doctor is going to operate you, he has to operate your stomach, he has to cut open your stomach. Okay. You cannot ask me to operate your stomach by going through your ear or through your head or something like that. There is a certain procedure in law
Sorry.
which you do not know.
Sorry.
So don't try to teach us.
Sorry.
I am telling you the procedure.
Sorry.
Now, supposing you want that person to be impleaded by name, who is going to implead, you or me?
You.
This court is going to implead. If this court is to implead, then I have to know the name of the person. To know that name of the person, that name of the person has to be there in your affidavit, in your application. It is not here. Who is he? Who do you want to implead? I do not know. Your application is defective. Now, how do I implead a person whose name I do not know, which is not here?
And page 17.
Page 17 is a different thing. Right. List the matter after the vacation. In the meantime, the applicant may submit a proper application. Next.
the matter to be passed over for the time being, after they elect.
Huh?
Okay, after some time, Doctor.
Item?
Review, my lord.
Yeah, for the private AIG. Any objection?
After the
Okay, right. Adjournment prayer has been made on behalf of Mr. On behalf of Mr. J.K. Goswami, standing counsel for the AIG. And the same is not objected to by Mr. Helen Dihingia. This is a matter after the vacation.
Can you see my lord 25th April?
Huh?
25th April.
Not so. You cannot hawk all the other cases are there in the registry.
Lord, this is my lord, metal password timing, my lord.
Huh?
Timing.
Actually, I should not have asked Mr. M.K. Chaudhary to review his instructions on the last day. His instructions are in favor of the petitioner. Huh? You can know, right? There's no question of objection. It's a question of the fact. That's what fact has been stated by Mr. Huh? What to do?
My lord, timing, my lord, metal. Senior counsel is particular. Yes.
Problem is Mr. Sahewala is not here.
Then
Last time you were not there.
yes.
So you said there's no point even if you are senior counsel. I'm not going to dispose of the matter. Because on the last date I could have disposed it of. You were not there. Today he is not there. But the issue is now clarified by Mr. M.K. Chaudhary. Nothing remains. Only thing is that since it's going to go in your favor, in his absence, prima facie, yes. And he has to be given a chance to be heard. Good. Right. A genuine prayer has been made on behalf of Mr. G.N. Sahewala. The learned counsel for the point number 2 and 3. So, sir, accordingly, place this matter after the vacation.
So that's 26, my lord.
Why do you want to hog all the dates? Keep some dates for the others. Second May, just right. Next para. This court, in its order dated 27/3/24, had reported the fact that Mr. M.K. Chaudhary, learned senior counsel for the IOCL, had submitted that as per the links of the Indian Oil One mobile app, one will be ONE capital, huh? ONE, the rate for HSD and petrol did not cover Shivsagar district. This is IOCL is not a party here.
Yes, if please.
Inflated. Can you give a small affidavit in the middle? Can you make a small affidavit? Okay. Yes, yes. Because, okay, right, so stop. Mr. P. Padwas, learned counsel appearing for the IOC, subject that he will file a small affidavit, file an affidavit to the above effect by the next day. This is the matter. Second,
But the item 25, my lord, is a content matter, my lord. But at this time, my lord, notice may go, my lord.
with regard to what?
My lord,
Contempt of what?
contempt, my lord, my lord, the same day, my lord, order, my lord, interim order passed, my lord, on 4 days. Same day, my lord.
No, you see, you see, the problem is, order was passed by this court, but their order was also passed on the same day. Then we do not know which came first. That's all. Just a minute. Yes,
Well, the settlement was made to the petitioner matter.
Huh?
Settlement. was
settlement was cancelled
made,
on the ground that you have sublet the market to some other
yes,
person.
and but the market was not sublet. It was allowed some other person, one of my friends, to collect the fruit.
To collect the toll.
And
You allowed him to collect the toll.
yes, that is I made
And what about the kist money? Did you give the kist
Yes,
money in
yes.
time?
Because-
Everything is paid till date.
no. My entire fishman was not paid, but my submission to loss in major, since I have deposited the 30% of the total settlement value as
Yes,
security,
30% of the
total settlement value
settlement.
as security money in advance. That is lost me penny to pay.
But that is security money. That's a different thing.
But if I was in default manner, that will be adjusted. So in that month of the case, my community has lost
Anyway, okay, so according to you, the issue only pertains to whether you had sublet the market or not.
yes, ma'am. And whether I was defaulter or
It's 32. It's 32. 32? No, 33 in my.
sorry.
Yes. Yes. I am not in position.
To buy this power. And then thereafter, my lord, that particular person, he gave public to one another.
Acha. From where do we get that? From your. Okay. Only one thing is that prior to cancellation, did you give him notice?
My lord.
Page 19. Yes.
Of the heart, that is not in the place of the heart, that is 50% or it is all clause, my lord, there are clauses, my lord, that if you violate the clause, my lord, yes, definitely.
Without notice. Where is that?
Not 70.
Not 7, he didn't translate.
Not 22 is the verdict, sir.
Clause 17 or clause 17? Yes, yes, what does it say? You can cancel the settlement on what ground? Has it been said? No, does it say that you can cancel? Does it say that you can cancel the settlement uh, after giving notice or anything that mentioned with regard to that notice or anything? Is there anything mentioned with regard to issuance of notice? Nothing. It's better. Oh. Yes. Clause 28. Yes. 28. Clause 28 is book receipt. 27. After which 28, I have got no idea.
If it follow the process from 92 and there is no provision for
But मतलब it is a fact मतलब that no notice of मतलब issued before the मतलब I
He
can
is saying that no notice is required.
but मतलब I am a lessee Miller and it is not the fact that मतलब the settlement was made to the other
Anyway, they can give you the ex post facto. I mean, subsequent notice can also be given to you. Any prejudice is caused by because of your letter, your power of attorney is here.
Yes Miller power is attorney
Then
yeah but subsequently
1/8 1/8 for
let me see that. So nothing remains, it appears. We'll tell them to give you a notice for Nam ke vaste only. If you are harping on that.
the power of
Purchased by Luktur Raman.
Someone is the page number 33, the power of attorney under the
Ah.
there the what
Second party is Sayruddin.
where my lord what is the my lord sorry.
no no
The power of attorney and that is an agreement with third party. Now he is totally silent with it.
His power of attorney holder, you mean?
Yes.
So according to you, you have no idea about this.
no man
No
and
idea.
मतलब subsequently it was revoked on 20th of December
Oh, it was revoked. When have you said that in your affidavit?
yes page 35
Page 35. Page 35, which was revoked?
my मतलब that power of attorney
Your power of attorney.
yes मतलब page 23
This was revoked when?
for मतलब 20th day of December 2023
20, 20 December 23.
yes it is wrongly typed as 22 but it should be मतलब
And
23
page 35.
due to violation of the terms and conditions of the power of attorney. Lost in my
Huh?
case 30.
Very good, very good. But then but then according to you, you are not in a position to do anything as per your earlier power of attorney. I am not in a position to proper management.
It is a fact, mate. Because Miller, the
Then you give up the market if you cannot manage. You know what I mean?
also engaging by some private person also, mate. So some लोगों को also consider Miller private person also, mate. Name of the private person is there, mate.
When was the impugned order passed?
Case Miller, the 41 Miller,
41.
21. And the decision that case Miller, the 38.
Okay. I don't think I've got any case.
Because Miller, the without notice, it is my Miller because violation of the national.
We'll take care of that.
Yes.
That part we'll take care.
Yes.
You can be issued notice. You issue notice now, but we are not setting aside anything.
My representative also pending before the authority that is also
Huh?
considered. My representation before the Miller, the speech and duty officer.
Your document, the official document really show. That is there also.
It could maybe met with my Miller to sort upon and some third person matter.
First party is the absolute attorney. No prejudice is caused to you by non-issuance of the notice. Right. Heard Mr. T.A. Kayum, learned counsel for the petition. Also heard Mr. S. Datta, learned standing counsel for the PNRD department. Then you take this order dated 22/2/2024, para 2 and 3. Okay. That's yeah. Next you're right. Next, Mr. S. Datta, the learned counsel for the PNRD department, has brought the official record. He submits that the petitioner had executed a power of attorney dated 17/9/2023 in favor of one Luftur Rahman, son of late Khairuddin Ahmed, for running the said Kirakara cattle market, hereinafter referred to as the market. Luftur Rahman subsequently handed over the management of the market to one Uddin Ali, son of Kaji Muddin, by deed of agreement dated 11/12/2020. It submits that as the petitioner could not have sublet the market to any other person in terms of clause 25 of the NIT dated 4/11/26. The There was no infirmity with the impugned order dated impugned office order dated 2/1/2024. Where is the cancellation?
Last letter, 10 minutes.
It is not 41. It is not 41. You're also not being fair to the court at all.
38.
Huh?
Some other person was allowed to continue, allowed to operate the market.
Yes, sir, whatever I said, whatever I said. Okay, you sit down. You sit down. What I said? No, with the cancellation of the settlement of the market with the petitioner in terms of resolution number 1 dated 29/12/2023 made by the meeting of the General Standing Committee of the Darang Zilla Parishad. At this stage, Mr. D. Kayum submits that the power of attorney dated 17/9/2023 has been cancelled by by has been revoked by the revocation letter dated 20/12/22.
Document 23
Huh?
only 22.
Where is the original?
next type, but it is only type में. If you do 23, page 33,
11, 20, 12, 20, 20.
page 36 मिला. Here is a date मिला 20.
No, no, there's nothing, there's nothing. Show me the original.
When I have no original मिला, this is मिला. Page
It's not-
37 also मिला.
Where, page 36, where is it? Where is it? I cannot read. Acha. Out here also it's 22,
20, 12,
20, 12, 22. Here also, page 37. Look at the last line. Again, 20.
Yes, that is the wrong miller. But the thing is, of the power, yeah, miller at notary. That is miller 20, 12.
Okay, 12, 23.
Yes.
I have heard the land passes for the fact. As can be seen from clause 25 of the NIT dated 4/11/2023. The lessee of a fishery, of a market cannot sublet the market to any person or institution. Full stop. On the other hand, the petitioner by power of attorney dated 17/9/2023 has appointed one Luftur Raman as his attorney holder. To collect the toll from the market and to pay all dues to the authorities concerned. Para 2 of the power of attorney dated 17/9/2020 states that due to financial hardship, the petitioner is not in a position to properly manage the bazaar, the market. And as such, he has appointed Luftur Raman to do all the to do all things necessary to run the bazaar and obey all the terms and conditions of the concerned authority. Subsequent to the above, comma, the official records that have been got before me shows that Luftur Rahman had made a deed of agreement dated 11/12/2026 with one Sair Uddin Ali to collect the toll from the market and to carry on the rules and regulations of the said market. In the deed of agreement dated 11/12/2026, Luftur Rahman has also stated that due to financial hardship and illness, he was not in a position to properly manage the market, and as such had appointed the said Sire Uddin Ali to look after the matter. So, sir, please, sir. The petitioner here has categorically stated that he was not able to manage the market due to financial problems, financial hardship, and as such had left the management of the entire bazaar to the said Luftur Rahman, who was to have direct dealings with the concerned authorities for running the market, including collecting all the tolls for the market. The above really goes to show that the petitioner had handed over the running of the market to other persons in violation of clause 25 of the NIP dated 4/11/2020. Next para. With regard to the petitioner's contention that he has not received any notice prior to the the settlement of the market being cancelled by the authorities, this court finds the said submission to be true. However, in view of the documents on record, that is the power of attorney made by the petitioner to Luftur Rahman and the deed of agreement made by Luftur Rahman with one Sairuddin. Sairuddin? Sairuddin, what is that? Sairuddin Ali. So, this court is of the view that no prejudice can be said to have been caused to the petition as the facts speak for themselves. Anyway, I'll continue. Basically dismiss. I'll keep this.
अरे सर my unless money maybe मिला तो then that after that just
That they will decide. There's nothing. You have violated the clauses. They will decide. Keep it. I'll just go through it. I've got to put something. Acha, one more thing you write. Further, the petitioner has not made any mention of the fact that Luftur so has made an agreement with Sairuddin Ali, which may amount to hiding of facts before this court. That's all, huh? And then the next point, you just write one more point, you just say, speak of the revocation of the power of attorney. Oh, that's where you have taken contrasting stance.
Both sides.
So, huh? Is it? Not a problem. It's fine. Because this will, because this will have a bearing in a number of cases. It's not only this. In some cases, you'll have taken this way, in some, you're going to have one stand. Correct, on, that's all. Good. Uh-huh. So different, this, so you're fine. Okay, right, Mr. T. Gogoi, Plan Counsel for the Excise Department. Please pay for 2 weeks time. To file affidavit in opposition, this is the matter after 2 weeks.
Interim order,
Interim order to continue till final disposal of the case.
highly okay.
It has to be. Huh? Now at 24th, I don't know, is it okay with you? You have to file the affidavit. Okay, 24th.
But 31 also similar issue.
So, okay.
29 for ordered.
May I please your lordship? And with this matter passed over for time being, my senior is late on court number 1.
My pleasure. We have to file one integrity.
Just give me the main case.
One integrity petition is filed with us. Right for challenging the order passed by the authority, the municipal report. Actual part of
Yes, what is your case?
we have filed a petition challenging the lot and non-consideration of our representation for extension of our period or period of our fees money.
What is your right to have your settlement extended?
Actually, my lord, immediately 1 month after our settlement, we have deposited the 18 lakh of rupees fees money, first fees money. Here the flyover and highway was there, my lord. So, এটা the traffic jam, my lord.
Huh?
It's not a traffic jam, my lord. To ease the traffic, my lord, because there is a construction of national highway by the side of my settled area.
So you knew that at the time of the tender, you must have known
I
it.
don't know, my lord. They know, the authority know, my lord. They have taken the money, fees money, and therefore we have represented before the authority. They know that huge area carve out to a sub road. So, my lord, we file a writ petition. As per that writ petition, my lord,
When did you file the writ petition?
my lord, yes. During my penance of my history,
When?
2000, my lord, 14 to 24.
You filed it in 24. And when did the road start?
My lord,
When did the road start?
it is road start, my lord. No, it is, my lord,
When did the road start?
it is, 28/5/23.
23 started, 25?
28/5/23.
28/5/23. Road started.
Yes, sir.
So when did you start running the market?
From my lord, 1/4/2023.
1/4/23. And in May,
May.
the next month, in the next month, the road started.
Road
Now,
started.
why did you come to this court
First,
in 23?
We have made representation, my lord.
Uh,
Several representations are made. In spite of that, my lord, second piece also, they have taken, my lord, 9 lakh, again 9 lakh. Hereafter, we have preferred the petition. The honorable court directly that we cannot stay the meantime, my lord, they have for the next year, they have to call for the tender, new tender, my lord. So the court says that no pay of tender, but however, you may also
Participate.
participate, but we cannot participate because due to the heavy loss, my lord. But the second part of the order to representation before the authority, we have made a representation. That representation was, my lord, rejected, denied on the plea that the municipality is running on the basis of the money and there is no provision to address the liberty. That is the point. They have not taken the point that there is a reduction of the my area of operation, substantially affect my right. So, my lord, we want to brought in the record because that petition is pending. So we have not filed any separate petition. So
There is a earlier petition pending.
pending is there, so that is pending. My lord. That is why I have to file intervening petition to brought into record this in order, my lord, the written order to rejecting our prayer. And my lord, this admitted fact, my lord, that huge area of marketing.
When did you file the earlier writ petition?
My lord, date is, my lord, yes, during my settlement agent,
From
not for.
you were not aggrieved in June, July, August, September. October.
Representation, several representation.
Representation after.
No, we have.
No, that is not that.
Not that.
That is not.
We have abandoned, my lord.
The only thing is that maybe he was.
That is the point. Because it is intuitive. Because substantially we have lose the my red and butter honey milk. Because I am paid first.
Let me see a representation.
Yes. Probably, my lord, she informed me. She is from the board, that municipal board. She informed that she has not received the copy. The copy of stuff. So she have the copy, but kindly see, my lord, that order, my lord. At page 16, my lord. The internet page. Page 16.
No, you see this writ petition.
Yes,
There is only one writ petition pending.
yes.
2 and 3. This is all.
Yes.
So what? There is no previous writ petition.
No, my lord. This is the
This is the only writ petition.
that is why we have filed,
You can challenge what is there.
my lord.
There is no bar to challenge.
Yes, that is the point.
If they want to challenge, they can challenge. They want to amend the writ petition, basically. You see, this is only an application to challenge.
Yes.
This can be allowed. Where is your application to amend the writ petition?
My lord, that is why this petition is filed. There is no necessary amendment because if this happen in the subsequent event, my lord, that is the order.
It's the council. So you want to challenge an order, correct?
Yes.
There is no bar to challenge an order.
Yes.
Only thing is that to challenge the order, you have to put it into the main writ petition. You'll have to insert it into the main writ petition.
If this petition is allowed, my lord, then I have to file the inserting the
You'll have to file an application for amending the writ petition. No.
I
Why don't you give?
but actually we are not given her because she is respond number 4, my lord. But it is seen that only government has been giving it.
But they are parties.
Yes.
All the parties have to be given.
Yes, my lord, that is true. She informed just now, my lord. I don't know that copy has not come.
The prayer is this. An application to allow the petitioner to challenge the impugned order dated 9/2/24, refusing to entertain the grievance of loss suffered by the petitioner. That's all. That order, now that is, what is the order page?
My lord. No, page 21 in the IML. The order is in consequence of your Honorable High Court order for its decision of this reason.
Page 21.
Page 21 of the interrogative petition.
So she wants, you see what has happened there? The petitioner's representation, this court directed the respondent by order dated 12/1/24 to dispose of the petitioner's representation. Okay. Not directed, gave liberty. So it was done. So it has been rejected. It has been rejected. Now he wants to challenge this application. So what is the bar? There's no bar. That's all. But then you see that after this, what is going to happen is you will have to ask for amendment of the writ petition. And after you ask for amendment, after it is allowed, then you have to file an amended writ petition. Inserting that order and maybe putting one or two paragraphs here and there, and even in the prayer portion. So my advice to you is, you withdraw this IA and you file a fresh writ petition. Simple as that, just challenging this order. That's all. Otherwise, you can do whatever, whatever. But I'll allow this petition, no application, no problem.
That, my prayer is that this petition may be allowed, my lord. And my lord, meantime, my lord, I have discussed because usually this, my lord, consent from the
No. It's not withdrawal of the main writ petition, only this IA. Because you are allowed to challenge the order. There is no bar for you to challenge this order. Okay, anyway, right. Heard, Mr.
TFA.
P.S.
Dekha.
Dekha. You're a senior counsel. Learned senior counsel, assisted by Mr. N.J. Sharma. S.J. Sharma. Miss
M. Sugop.
Huh?
M. Bhattarji.
M.
Bhattarji.
Bhattacharjee. Bhattacharjee appears for the respondent number. Who else? Mr. G. Bokailal appears for respondent number 1 to 3. Who is for 5? Okay. Then the petitioner prays that he may be given the liberty to make a challenge to the order bearing number BRMB/T-18/2023/24/2446 dated 9/2/2024, issued by the Office of the Barbita Road Municipal Board, rejecting the petitioner's representation. Correct?
Yes.
Which had been made pursuant to the order dated 12/1/24, passed in WPC 213/2020. The counsel for the response submit that they have no objection to the same. No, sir. In view of the submission made by the counsel for the party, the prayer of the applicant is allowed. Applicant is allowed. The IA is accordingly disposed.
Because I have another prayer, my lord, that during Senate, they are demanding by the order, my lord. So that they for 6 months also I have to pay it. It is otherwise was expensive. But it is for next that never.
No, where?
Last for Damilo.
No, no, no. No, no,
That part
that is a different issue. Right now, so they can't do anything against it. That is a different issue. Put it. Main case, you just settle the matter after the case.
Time being item 29. Well, it is earlier file on I file on IMI. And I withdraw my
Huh?
earlier I file on one IMI. You may remember. There is one total from 61 petitioners they are eligible to get the matter and 87 not matter. And by the petitioner advocate submitted before the honorable court is covered by one judgment of the matter. So it is
But you said it was covered.
no, one of my colleague Malad is on the state Malad is consent was given.
So haven't you given a copy to the
I
petition?
request Malad, he denied Malad. No, that may be told, Malad.
Okay, right. Heard Mr. S.K. Medi, learned counsel for the review petitioner, who submits that the impugned order dated
23/11/2021.
2021, passed in WPC 6603 of 2014, should be reviewed in as much as all the petitioners in WPC 6603 of 2014, all the writ petitioners, all the writ petitioners in WPC were not similarly situated employees with the writ petitioners in WPC 1537 of 2014. Out of 2015. Out of the 148 writ petitioners
61.
in the present case, only 61 writ petitioners were holding the post of Superintendent BR grade Roman 2 as on 1996.
119.
1996. Full stop. Therefore, only 61 writ petitioners were eligible for grant of arrears as per the judgment and order dated 18/2/2022 passed in WPC 1537/2015. Full stop. The remaining 87 writ petitioners were not holding the post of Superintendent BR grade Roman 2 on or before 1/1/1996, nor were they appointed post implementation of the recommendation of the 5th and 6th CPC. However, while the impugned order dated 23/11/2021 passed in WPC 6603/2014, which had been made on the basis of the order passed in WPC 1537/2015, all the writ petitioners in the present case have been granted the benefits provided to the petitioners in WPC number 1537/2000. It submits that the consent given by the counsel for the review petitioners in WPC 6603/2014 by stating that WPC 6603 of 2014 was a covered matter in view of the order passed in WPC number 1537 of 2015 was factually incorrect due to the reasons stated above. Full stop. If you notice, returnable in 4 weeks, 3 weeks, what, 6 weeks, what?
6 weeks.
Why 6 weeks?
4 weeks. 4 weeks. Yes, sir. And document allow also the paper copy also.
4 weeks, 4 weeks. Petitioner to take steps for service of notice. When the petitioner takes steps for service of notice upon the writ petitioner slash respondent's number, respondent number
Minus 1 to minus
1 to 148,
48.
1 to 148 by way of newspaper publication.
Yes.
In 2 newspapers. They are all of the same.
No, madam. Some West Bengal, some Uttarakhand.
2 national newspapers.
National.
2 national newspapers.
Yes.
Okay, 6 weeks, make it 6 weeks.
6 weeks.
And the review petitioner shall thereafter file affidavit of service.
Highly okay.
Madam.
No, what was there was, one point was the rejection. That was, he did not sign the document. That is the main point.
There are 2 counts. One lordship has already held that it is not necessary because the affidavit that I have submitted in the repeat,
That I have allowed.
and
Ah.
that lordship has said it's
Now is whether the second, all the pages have to be signed or not.
signed. The other day, madam, some document has been produced and
One document was not signed.
one document, lordship will find it in the order dated last order, madam, dated 21/3/2000.
Ah. Yeah. That's the first thing, is certificate number so and so.
Lordship has considered various clauses and lordship has come to a spelled opinion that all the document has to be signed. Lordship has gone through the various clauses.
He has not put it here. The doc- So, okay, it's in this bunch of documents.
Some of the documents I have also filed today, where his signature is not there. And your lordship's observation in paragraph 9 of the earlier order, if I'm permitted to read, madam. However, with regard to the other grounds of disqualification of the petitioner's technical bid at the technical bid evaluation stage, But the same document we have also filed for today, that will be at 10113 additional.
Just tell them to look for it. It's all. Not big. I'll just write for around 5 minutes. Huh?
So that once we have submitted today.
Or it was submitted by them.
Right. Same document is also there, page same document, 113.
Page 113 of your affidavit.
I mean, that additional bunch of the plot, right? Additional affidavit filed today.
Listen. Listen. This, no, not this. This one. This one. Yes. Ha ha ha. 51W. Ha ha ha.
That document I look for that document for required. Either to fix it. It's okay. But it does not follow the identity or system. That is called it. But the other texture was as you said. I it and which is not that are
These are the photocopies. These are photocopies. You have not brought the original. Anyway, he's not denied the fact that he did not sign. You are denying.
No.
You're not denying that. Yes.
The whole,
Huh?
my contention was that particular clause having been relaxed in the case of the private respondent, then should have been relaxed in my case
Ah.
also. That is the whole case. And therefore, the doctor has, or the earlier occasion has discussed entirely clauses and also observation. That's the body is.
that very document.
No, in his petitioner's document, this document is not there. It's not required. So according to you, since it's not required,
This
Ah.
is only in case of rented premises that document is. Although it is not specifically mentioned in the tender.
Landowner who says, who I have a tenancy agreement, that agreement is connected there, where I have signed. What is that I have,
you're for the government. Then
yes, it's under the government. I have to. So,
We have, the state service. we
you're
have
for the private respondent.
the very document, which just under it, that's not signed. For the, that, which has also.
What is this affidavit? This affidavit.
But there is no, I have figured this land on that.
No, that is a requirement. Unless he has to prove that that
He has given a tenancy agreement. That document is there. This was some extra care, extra apartment for the
Affidavit.
file, this now. This the part of health. Disturbing the interest. That apartment. That was the kind of years old. But it's also a small kid. Just I can cross car of one of the. That is.
No, Ronak International, you see, Ronak International may not be applicable fully here. Because his case is on a different footing. His case is when you apply a certain clause, it has to be applied equally. That's the case. So that in those other cases, so the petitioners therein has been disqualified on due to a violation of certain clauses, while the petitioners had said that the successful tenderers, they should have been disqualified on the basis of some other clause. So that's the difference of it. Out here, what he's saying is a clause 5. He says that clause 5 has been applied differently to me and to the, so that is basic. So Ronak will not come in. Page 35. Yes. Verified. Yes. Okay, okay, yes. Enough. Six point two point one to 6.2.20. So these documents have to be signed. Yes. So other documents which are beyond this 6.2.1 to 6.2.20, even if they are filed, need not be signed. Yes. That is a question. That's what I'm saying. Even if they are filed, it's not required to be signed. No, so you mean to say that the document which was recorded earlier, that is not included among the 6.2.1 to 20. And all these other ones are all signed.
It can file an affidavit whether new dimension has been brought in, whether that document is real or not.
No, but so they've said it.
Yes.
They have said it. Now you have got to run a count. You have got to make a submission with regard to what they have said. Basically, you see, the issue is as per this clause 6, documents that comprise the bid. So documents that comprise the bid, according to him, is reflected in 6.2.1 to 6.2.20. Now, he says documents which are not included among this 6.2.1 to 20, even if they are filed, which is not a requirement, they need not be signed. So what is your take on that?
The first they have come up with definitely need time method to.
No, what do they say? Yes. And then, Original deeds need not be signed. Okay, so that is your argument. The twofold argument. One is that only documents which belong to 6.2.1 to 20 are to be submitted. If you submit beyond that, well and good, you have submitted, but they need not be signed. Also, 6.2.1 to 6.2.20 are to be signed only if they are photocopied. If they are original, need not be signed. So his case is that the document that was mentioned earlier in the earlier proceedings, that is not a requirement as per the clause 6, and that original documents need not be signed. That's it. So if you, I do not know what is that. You want time or you want to argue this on this?
But I have to, in this case, I have to verify even my documents which are, as per clause 6 and clause 6, those are not signed by me, number one. That takes little time. That's second.
No, okay, that is one aspect.
That is one. So for that, I'll be needing time. But so far as the clause 6.2.5, where the income tax return and the balance sheet are to be certified by the CA. They are not replying to that.
6.2.5.
Page 34, man. No, this is a previous case. I have a document, annex the documents also, man.
Actually,
You submit truncated documents only to select.
no,
documents somehow
no,
want-
he can take all the available avenues. Huh? He cannot go.
I cannot go.
Is it there in your pleading?
Yes, of course, that is my main case.
Where is it?
Yes.
It depends upon his, depends
yes,
upon
I-
his pleading.
I say that in the similar circumstances regarding IT, it is item number 28. Their lordship has stated because IT document was not certified by the C. So therefore, similar order I have annexed to that. On the other day, he has submitted a truncated document only with few documents, but somehow one document comes out to be like it without the signature. Somehow, now I have in the documents, I have submitted many documents where he has not signed. Now all the documents, whether will be covered by 6 or not, clause 6 or not, that is definitely required. But so far, clause 6.2.5, he has not answered to that.
6.2.5 regarding income tax returns, that is, and statement of net worth as certified by Chartered. So the statement of net worth has to be certified. Income tax returns, is it required to be certified? Certified, that also.
Look.
ITR and the net worth.
Copy of income tax return along with balance sheet for the year 2019, 20, 2021, 2021, 22,
Let
2023,
Mr. D. Gogoi,
and statement
let
of
him
net
come. He's starting to look like a pressure cooker.
I just like one. Mentioned in page number.
Ah.
It's not a case. In that case, it's a what I call what I it's some case for the
I don't know.
Let me see. Para.
Let's will come to paragraph 10 first. Let's will come to paragraph 10, madam.
Yes.
Fourth line from bottom. But the income tax returns are submitted by the respondent number 5
Are not certified by Chartered
chartered
Accountant.
accountant.
Para 10 is there.
And the 15 that I have annexed because on the same ground, the in another case and interim order has been passed.
Anyway. So anyway, look, you want to say something? I think, look, the way he's looking at me, he's,
there are check certified but for certain whether it can be whether it can be all different to the fact that it is the power then it can be I'll come up with all these
the argument, just I put my pen, it is not, whether he has that power. Because
When, Mr. Council, when it's a requirement, and if other bidders can have the IT return certified by a chartered accountant, why can't you do it?
not profit, profit, not justified, like, but whether it is part under the income tax act.
It is not a question of bar, it's a question of the clause of the tender.
I,
You see, you are not the author of the tender document. Now, the author has just now spoken. His word, according to the Supreme Court, is law. Now, what he has said is that as per the clause 6, the recognized documents are these. Now, whether they play around with the clauses, is something which can only be done by them, not by you. Either you fall within the interpretation given by them, depends upon them, not you. The only thing the petitioner is saying is that a certain clause has to be applied equally to everyone, cannot be applied separately for different persons. That's all.
but
Look, did you submit a ITR certified by a chartered accountant? No. There's no, you can do it. What I'm saying is that if he has done it, why can't you do it? That's what I'm trying to say. Anyway, to cut short this, we're not going to finish this matter today, it appears. So you both file your affidavit. Whatever you take it, you file it by tomorrow also doesn't matter. That depends entirely up to you. Huh? Yes. Okay, right. Mr. PJ Saikia, Madam Senior Counsel appears for the petitioner, while Mr. D. Gogoi appears for the Excise Department. Mr. M. Biswas appears for the respondent number 5. Stop. Mr. D. Gogoi, the learned counsel for the state respondent submits that all documents in a tender, all the documents in a tender, in the bid submitted by a tenderer need not be signed. First off, he submits that the documents that comprise the bid is clearly provided in clause 6 of the NIP dated NIB dated
23 to 2024.
23
February.
to
23rd
2024. NIB, no? NIB. NIB. First off, he submits that clause 6.2.1 to 6.2.20 specifically provides the documents that have to be submitted along with the bid submitted by tender. Those documents mentioned in 6.2.1 to 6.2.20 have to be signed, if they are photocopies of the original. First off, however, original document did not be signed. That's your case. Original document did not be signed. Good stuff. Original affidavit, original sale deed, original affidavit and deed. What about original ITR return?
Well, all these things.
Anyway, okay. So, however, the original affidavit and sale deed need not be signed.
My submission.
Just a minute. My train of thought gets lost. I'm not so brainy as you are. That's the problem. I have to take it slow. Yes. Now, where was I? Okay. Full stop. Submit that. Need not be signed. Full stop. He submits that the certificate number IN-AS 730-295-937-8775 1W mentioned in para 14 of the order dated 21/3/2024 was not a document which was required to be submitted along with a bid in terms of clause 6 of the NIB. As such, the said document, which is not a part of clause 6 of the NIB, was not required to be signed. Next. Mr. M. Biswas appearing for the point number 5 is granted. No hurry, you can do it Wednesday also. Wednesday is a working day. Only motion days are declared. No more, no more. It's after vacation only. How many weeks do you need for filing your affidavit? Okay, he's granted a week's time to file affidavit in the position. Yes, Mr. Sakia, what do you say? You wanted to say something in the middle of the order. Even you have lost your train of thought. See.
I was, instead of my physical inspection submitting report or the affidavit on a particular point, there are several other grounds also that if you file a detailed affidavit, better can be
Right. In the meantime, the excise department may also file an affidavit, comma, if found necessary. Full stop. Anything, or you want to do anything? You want to file anything? No.
Subject to what he filed in the affidavit, I may have to reply.
Okay, list the matter after the vacation. Interim order passed today shall continue to the next week. Give it. Publish. This is everything. This Satyajit Morning Morang, who's this? Yeah. Okay, it should be in the file. This. What is this? Tata Motors. Tata Motors. What is that? Hearing?
Also, takes time, lot of, it is date of the month of May, it
You want to adjourn?
will take time, lot. It will take time.
There is no time.
We have taken the consent also.
Okay, on the prayer of the parties, list the matter on
In the date of May, 14th May,
14 minutes.
okay. I'm being item 30 to 50.
Thirteen to 15. Huh? Thirteen to 15. Settlement of San Mahal. What is to be done here? You are for the petitioner. What is your case? Huh? You are for the state. Huh? You are for the writ petitioner or not? You are for the writ petitioner. What is the writ petitioner's case? Why it was rejected? On what ground?
shortage of document.
Shortage of documents. So is that a fact? Is that a fact? But they were given they were settled with the with the mall. Huh?
Your
Not settled.
lordship, final
Yes, take.
settlement has not been done, but and CTC has approved the Mohol in favor of me.
Okay.
And the respondent number 8.
Okay.
And in this, I am the applicant.
So tell me, it is a fact that you have not submitted all the documents in time, correct?
Yes.
No.
No, no.
When was the last date of submission of your tender document as per the NIT? Let us see the NIT.
Page 18 to 24.
Page 18. Ah. It has been signed today, filed today. Then what to do? All motion due now. Hearing so I don't think. Motion, all motions now, order has been issued by the Chief Justice that Thursday, from today onwards, till Wednesday, all motion days. Okay, Mr. P. Nair, Senate Counsel appearing for the BTC submit that affidavit in opposition has been filed, will be filed today. Is being filed. Is being filed. According to Mr.
M. Ahmed.
M. Ahmed appears for the respondent number 8, while Mr. S. Alam appears for the respondent number for the writ petition. Accordingly, in this matter, 19. 19.
19.
21, 19. Math 19. Interim order to continue till the next. Item 20 and 21.
The old case followed satisfied challenge the cancellation order and the notice followed the allotment of the principal that particular room in a market. Now they have filed as per the direction of this report. They have filed recently affidavit in opposition on behalf of executive official of the Supreme Municipality Board. That's number 2. I have filed a reply. I am objecting that the person who signed the affidavit is no longer holding that book. He is presently posted at ADC to Dibrugarh. That is one point.
No, at the time the affidavit was filed.
No, he was not there. At the time of filing affidavit, he in the affidavit, he himself stated that I am holding the post of ADC Dibrugarh. That cannot be a person holding the post of earlier. He holding the
Correct,
post.
correct.
That is why my prayer is so
Ah.
But at present, how can he?
No, Mr. Counsel, at the time he filed the affidavit of position, was he holding the set post? Let us see your affidavit of position.
No, it is distinctly mentioned. He is presently holding the post of ADC Dibrugarh.
And
So my respect to
which one? An additional affidavit of position? Which one? Just a minute. This affidavit is affidavit. We're talking additional affidavit filed by whom?
Rason number 2. He stated to be the rason number 2 of the
Additional affidavit? It should be affidavit. Now this is he is Jintu Bora. Third then executive. How can he find third then?
Malad, my representative
He cannot find.
Malad,
Oh, he is with party.
not made party, Malad. My contention and my
Yes, sir,
reply
yes,
is
sir.
specific, Malad.
Yes,
I
yes,
have not made party by name, Malad.
yes, let me see the first side.
Person number 2 is the executive officer, Dhuri municipality board. He is not made by name, Malad.
Not
Nowhere.
party, no.
So, quantum is altogether different thing.
But
Malad,
different.
we are in the writ petition, Malad, here. My expression submission is for losses.
What you do is, you do the same thing and let the present respondent number 2 sign it.
My humble prayer, Malad, it's already getting delayed, Malad. Malad, anything in a fixed date and direct them to produce the relevant record before the court. Malad, everything will be clear, Malad.
Let the report are here. It is.
But in a fixed date after reopening, Malad,
Why
after
it can be heard now also. If you're in urgent, if you want, if it's urgent, I can hear it now. What is this matter regarding?
Malad, cancellation on the allotment order that
Okay, that's all.
stall, Malad. Malad, without giving any notice, they have done this. That is why I filed the petition. There is a interim protection given by they violated the protection. That is why connected matter is the containment. So EOLOC's earlier petition directed to taken up both the matter together and instructed directed them to file an affidavit. The affidavit is cannot be considered because that person is
They can file a fake affidavit. There's no bar. To file a fake affidavit. Okay. No, but you file here also. Then you cannot say the then. The then is not a thing. Supposing we ask the chief secretary to write. Can a chief secretary after 20 years say, I was the then? Cannot happen. Okay. Then Mr. P.S. Bhattacharya submit that he has produced the records, he has brought the records, and that he would like to file an affidavit in the position on behalf of the respondent number 2. In as much as the earlier affidavit in the position dated 14/11/23 had been signed by one Mr. Jintu Bora, who was not the respondent number 2 on the date of filing the affidavit. Praise the Lord, this is the matter.
Malad, sir, it will be too long, Malad. Let it be in the reopening of the
Election, when is the election? Huh? Election duty.
July, Malad, it cannot be, Malad. That cannot be, that excuse,
Just a minute. Why are you shouting, both of you?
Malad.
Let me ask questions to both of you. Just a minute. When is the election date in Assam?
Malad, 19th first, then 26th, then 7th of May, the last day.
Then after
That is why my humble prayer is for
After that, after 7th, because where is he posted? Where is his? So he's going to have election duty in Dubri. So Dubri is going to be election when?
7th.
7th.
So now prior to that,
Prior to that, they can do.
there will be no, Malad, those officers will not involved in these first 2 phases.
Correct. Then you do it. this month.
Reopening, Malad.
You do it now. You do it next week. Huh? So what? Just take one day and you come back next day, just sign it. After end of the month. Mr. So paper. Are you filing anything? Mr. So paper final post submit that. The respondent number 4 will not be filing any evidence. Correct? No affidavit.
Make it clear so that on 26th April, prior to 26th April, they can file the affidavit. Otherwise, it will be again delayed.
Any affidavit to be filed by the respondent number 2 will be filed prior to 26. If
Highly obliged.
Lordship, I'm sorry, Lordship. My supplementary item motion has escaped your Lordship for non-appearance. Can it be referred tomorrow, your Lordship?
I'm sorry, it's too late now, Mr. Counsel.
I was sitting, but somehow I was sitting here, Lordship.
You're sitting here.
Yes, your Lordship. Somehow, how can it
Supplementary.
motion? I was sitting, Lordship, in this court, your Lordship. There, tomorrow, Lordship.
Is the OTS scheme valid?
Yes, your Lordship.
Is
I
it valid
submit-
till? No, that is a judgment of this Meghalaya High Court a long time back. Show me the scheme. Where is the scheme?
Scheme I have not collected, but I
Yes,
have relied upon
because probably the scheme is not valid.
scheme, Lordship, but this judgment and another judgment of our
This
High Court-
judgment depends upon the scheme relevant at that time.
Yes.
Show me the scheme.
And the 2016 judgment is also there.
Now it's 2024.
Yes,
8 years have happened. 8 years, anything can happen.
so Lordship, then maybe fixed on tomorrow, Monday, Lordship, I'll try to collect that scheme.
I think item 23, 33, is that right? Mr.
Yeah, sure.
Here from appears for the petitioner. He submit that the petitioner has submitted a representation for payment of his dues by way of one-time settlement, OTS. The petitioner has not annexed any OTS scheme in the writ petition, and neither has he made any averment with regard to whether the OTS scheme that the prayer for OTS that the prayer for OTS um, uh, what do I say? And neither has he made any averment that the OTS scheme is valid till a particular date. He has only relied upon judgment passed by the Meghalaya High Court.
Yes.
However, the same does not reflect the validity of any OTS scheme which the petitioner is seeking to avail of. Accordingly, the petitioner shall submit the OTS scheme which the petitioner seeks to avail of, and by the next day. The said OTS scheme should specifically state the validity period of the OTS. This is the matter on Monday.
Monday. Oblige, Lord.
No. Okay, when? Second. So, Mr. Counsel, I think you have to get your OTS scheme
I'll
validity.
try, Lordship, I'll try.
Because
that part.
you cannot ask just like that OTS scheme. Correct? If
Yes.
there is no scheme, there is a question.
Lordship.
Need be your Lordship. So on the last occasion, Lordship, we have basically completed our submission. Today we have prepared a written submission for Lordship convenience. Whatever we have stated there and the judgment also which we have decided.
Our main thrust is relating to paragraph 42 of the judgment, which Lordship will find at page 43. Paragraph 42 says, reverting back to the case of Shiksha Sarathi, we find that notwithstanding their initial engagement for 11 months, their engagement have discontinued for more than a decade now. And as a matter of fact, their engagement is now in the second decade, which clearly indicates the necessity and utility of Shiksha Sarathi as assistant to the teacher. So this was the main area where we sought the review. In support of that, Lordship, when we started the exercise for complying with the judgment, Lordship, then we found out that they were not working for a long time, and which is now an admitted position of their own record. The Lordship is pleased to take my written submission. Page 3. Page 3. I am reading the paragraph one, the middle paragraph. Since the direction contained in the judgment and order dated 26/10/2017 has become unimplementable in view of the fact that the petitioner had been discontinued in service after their initial contract period of 11 months, the present review petition has been preferred. Therefore, although there is no pleading in the writ petition that the contractual period of the petitioners has been extended from time to time and they had been continuing in service, however, at paragraph 42 of the state judgment dated 26/10/2017, a finding has been arrived at that the engagement of the Shiksha Sarathi have been discontinued for more than a decade and as a matter of
Have been continued.
have been continued for more than a decade. This
No,
is basically-
not discontinued, continued. Initially, you had said discontinued.
sorry, have been continued for more than a decade, and as a matter of fact, their engagement was in the second decade, which is incorrect without any evidence, which is evident from the following statements and averments in the writ petition. In paragraph 2 of the writ petition at page 179, the petitioner stated that they were engaged in the year 2003 and are aggrieved by non-receipt of their remuneration as well as against the action of the respondents to replace them by new sets of recruits after extracting their services from them for 7-8 years. That is one statement they have made in paragraph 2. In paragraph 10, they have stated that although the agreements were signed on 30/9/2004, virtually their engagement continued up to 2010, and even as on date, the petitioners are continuing to render service. What type of service they are rendering, that certificate will reveal now. At paragraph 14 and 15, the petitioner stated that they have been continuing since last 7-8 years. So now, in the affidavit in opposition, they filed to the review application, they annex certain certificates. Those certificates also we have quoted the relevant portion. In the affidavit in opposition filed by the opposite party writ petitioner, in review petition 149, the document annexer B colleague, which are certificates issued by the headmasters, clearly mention the following quoted in verbatim. In respect of Nipun Methi, he served as Shiksha Sarathi 1 in the school where there was only one teacher under the government approved program of Sarva Shiksha Abhijan mission for the period 2003-2004 to 2005-2006. And from 2006-2007 to 2007-10, he served as a teacher in each 11 months appointment phase in the state period.
So what does it mean?
So this is their certificate. Yes. If Lordship is to take their reply affidavit, they have annexed it at
This
page
is the
13 and
page-
14.
Page 13 and 14.
Yes. Correct, page 13. In respect of Nipun Methi. For convenience, we have quoted it in our
Nipun Methi.
fourth line. He served as Shiksha Sarathi 1 in the school where there were only one teacher under the government approved program of Sarva Shiksha Abhijan mission in the period 2003-4 to 2005-6. And from 2006-7 to 2010, he served as a teacher in the each 11 month appointment phase in the above period, I wish him bright future. This is the first certificate.
What does it mean?
This means that he was working as Shiksha Sarathi up to 2005 and 6.
Yes.
Thereafter, he is working as a teacher. In what category of teacher? This is their certificate. What if they will have to give the estimate. But my understanding is very clear that his work as a Shiksha Sarathi was over in 2000. Our date is 1st June 2006. From that day onwards, there was no Shiksha Sarathi.
After 1/6/2006.
1/6/2006. That also we have quoted in our written argument. Then next certificate is Surya Kumar. At page 15, Surya Kumar certificate says, this is to certify that Surya Kumar worked as a Shiksha Karmi in the New Horizon scheme of SSA under different school development schemes of SSA in the Mohpur Primary School from July 2003 to February 2004. Stop. And his involvement as trained Shiksha Sarathi in the Mohpur Primary School has been authenticated from different sources. After that, in the year 2006-7, he rendered his service as Shiksha Karmi for 11 months in the school. Besides, it is also true that he served as volunteer teacher from 2007 to 28 December 2014 in the Mohpur Primary School.
What is the difference between Shiksha Sarathi and Shiksha Karmi?
Shiksha Karmi, Lordship, we do not have that termination. We have Shiksha Sarathi and we have Shiksha Mitra. Shiksha Karmi, this gentleman has been. Under the SSA, there are two categories. One is Shiksha Mitra, one is Shiksha Sarathi. And now here a new term has been introduced, volunteer teacher. Now coming to the next gentleman, Lordship, Hiralal Boru, page 17, second paragraph. As it is impossible to impart education as a lone teacher in Lokapria Primary School, the executive meeting of the School Management Committee on 17th April 2002, in its first proposal, allowed Hiralal Boru to serve as honorary teacher in the school. So at that time, the Shiksha Sarathi was not introduced also. The certificate came in 2003. Later on, from 2003, he was engaged as Shiksha Sarathi 1 and community volunteer under the scheme implemented by Sarva Shiksha Abhijan Mission. He served in the post till 31st March 2010 in the one teacher school. Moreover, it is true that Boru did his job as assistant teacher in the Lokapria Primary School till 31st March 2014. So as assistant teacher, he is working. Who is paying everything? We are not sure about that. Why he was allowed by the headmaster to work, but he was not a Shiksha Sarathi after, according to this certificate, 31st March 2010, which in fact is not correct. Then next certificate at page 19, Mohat Chandra Rabha, second paragraph. Mohat Chandra Rabha worked as Shiksha Sarathi 1 under Sarva Shiksha Abhijan Mission in the scheme of one teacher school at Puijola Tengakhal LP School from 2003 to March 2010 as per the approval of the General Meeting of School Management Committee. Again, he was engaged as community volunteer by the SSA in the same. So he was not there since 2010, at least. It is to be mentioned that on March 2010, after conclusion of the term of community volunteer, Mohat Chandra Bora has been rendering his service in the school till date without pay for the future of the children of the school. So here there is a conflict. At one time, he is saying that in March 2010, he was working as community volunteer. And the previous paragraph he says, till March 2010, he was Shiksha Sarathi 1. There is a direct conflict here. Paragraph 2 and paragraph 3. Then page 21, Karnadhar Kochari.
Sri Kochari rendered his service as Shiksha Sarathi 1 under Sarva Shiksha Abhijan from 8 August 2003 to June 2004, 11 months, and again from 11 September 2004 to August 2005, 11 months. Altogether 22 months time in the Tupangbari Primary School as per proposal passed in the general body meeting of the school management committee. After the expiry of the above term, he continued to serve in the Tupangbari Primary School as honorary teacher. When he did not get salary any work under SSA in the Tupangbari Primary School on 23rd August 2007, he joined as community volunteer in Jimkuta Primary School for 7 months after signing an agreement with the school management committee as per proposal passed in the general meeting of SMC of the Jimkuta Primary School. It is to be mentioned here that on March 2008, the term of community volunteer came to an end. In spite of completing the term, Sri Kochari used to serve the school without any pay till date. His presence in the school is regular. And lastly, there is a last certificate at page 23 of Horisaran Rabha. This is to certify that Horisaran Rabha worked as assistant teacher under the scheme of Shiksha Sarathi 1 of SSA in Borgaon, Bokorpara Primary School from the month of December 2004. He has been still serving as assistant teacher without pay in this school as per the approval of school management committee up to 29th February 2020. So all these are irregular activities, which has nothing to do with the Shiksha Sarathi scheme of 2003 up to 2005.
This 8 is wrong in page 23. How can it be 29 February 2020?
It can be, Lord, because that was a leap year. This year it was leap year,
No,
2020.
no, I'm saying, when was the academic cycle?
His affidavit was filed
Because
in
the file,
in 2000
18 June 2020.
18 June 2020. So 29 February was there in 2000. This is their admission. And what is our finding? Because when we did all these things the other day, then my learned senior friend was saying that they belong to the Kamrup district. In our review application, we also know aware that it is related to Kamrup district, because if Lordship is pleased to look at the cross title of the writ petition, it is Kamrup District Shiksha Sarathi 1. They have filed it. In our review application, page number 53, and before that, I will take your Lordship to paragraph 9. Page 9.
Page 53,
Before that, page 9
page 9 of your
of our review application. 149 of 2019. Paragraph 9. That the review petitioner states that the Shiksha Sarathi SS1 and SS2 were engaged in the year 2003 to 2005 on contractual basis, and their services were discontinued since 2006. Meanwhile, as many as 9 number of field level jurisdictional officers of Kamrup district have an inquiry confirmed on 23/2019 that none of the members of the petitioners association is working in any of the schools under their jurisdiction. It is also pertinent to mention herein that there is no post in the school against which the members of the petitioners association can be adjusted. So that report is at page 53. Office of the District Elementary Education Officer, DEO, Kamrup, statement of as regarding engagement of Shiksha Sarathi in Kamrup district. I, the undersigned, have got page 53. I, the undersigned, do hereby confirm that no Shiksha Sarathi is working in the schools under my jurisdiction. So all the 9 DEOs or DIs have signed it. They have made an inquiry. Which date? Date is, Lordship, at page 9, at 23/2019.
Although this page does not indicate, but in our affidavit, we have mentioned the date at paragraph 9. The third line, as many as 9 number of field level jurisdictional officers of Kamrup district have made an inquiry confirmed on 28 March 2019 that none of the members of the petitioners association is working in any of the schools under their jurisdiction. So we have given the date. And if Lordship is pleased to direct, we can produce the original also. So this is our position. Because I don't have to argue much because it is a review application. The finding in paragraph 42 is directly in conflict with the ground reality. And in fact, it was not, I have discussed with my friend because I was not appearing before the constitution bench on the earlier occasion. So there was no occasion to look into this. There was no debate on this point, whether they are continuing or not. Because from our state side, only 2 submissions were made that it was a covered case and Uma Devi's case. Our state side, page 27. Page 27, paragraph 15. On the other hand, the so-and-so learned standing council SSA has raised twofold objections to the prayer made by the petitioner. The first objection relates to res judicata, in respect of which he submits that the earlier division bench case in Orup Kumar Punya has finally decided the issue raised by the petitioner and the same cannot be reopened again. Secondly, on the issue of regularization, he submits that appointments of the petitioners were contractual in nature for 11 months, which they had accepted. Therefore, petitioners cannot seek regularization of their service. In this connection, he has placed the following citation. So basically, these are the 2 arguments. So in our written submission, we have mentioned 3-4 judgments of the Honorable Supreme Court regarding the law relating to review, which Lordship will find at page 6 of my submission. The ratio is of these 2 cases. If any apparent error noticed by the High Court in respect of any orders passed by it, the High Court has not only power but a duty to correct it. The High Court's power in this regard is plenary. We have cited 2 cases, 2000 volume 1 SCC page 666, paragraph 13 and 14, and 2019 CSCC page 203, paragraph 10 and 13. Lordship, once I can please read it out, the relevant paragraph. 2000 volume 1 SCC page 666. MM Thomas.
This bunch of is from you, or is it from the other side?
We have given the citations and we have gave the
And then 2,000.
I think this is ours.
all the cases which we have mentioned in our written submission. In addition, Uma Devi's judgment is also there.
Two thousand one, it's
2000, volume 1 SSC, page 666, Thomas. versus
MM
State of
Thomas, no. This is who? Huh? This is the budget. Yes, number 6. Right. Here's number 5, okay.
Paragraph 13. In this case, we are not concerned with the power of review of the Forest Tribunal. It was the High Court which reviewed its own judgment, and so the question is whether the High Court has the power to devote section 8C of the Court. Court of review conferred by on the Supreme Court under Article 135 of the Constitution is not specifically made applicable to the High Court. Does it mean that the High Court has no power to correct its own orders, even if the High Court is satisfied that there is an error apparent on the face of the record? The High Court, as a court of record, as envisaged in Article 215 of the Constitution, must have inherent power to correct its record. A court of record envelops all such power whose acts and proceedings are to be enrolled in a perpetual memorial and testimony. A court of record is undoubtedly a superior court, which is itself competent to determine the scope of its jurisdiction. The High Court, as a court of record, has a duty to itself to keep all its records correctly and in accordance with law. Hence, if any apparent error is noticed by the High Court in respect of any order passed by it, the High Court has not only power but a duty to correct it. The High Court's power in this regard is plenary. In so and so, a 9-judge bench of this court has recognized the aforesaid superior status of the High Court as a court of plenary jurisdiction, being a court of record. This is the first judgment. This judgment is followed in 2019 3 SCC, page 206. Municipal Corporation of Greater Mumbai and another versus Fortify Industries. Paragraph 10 and 13. Paragraph 10 says, insofar as High Court's jurisdiction to recall its own order is concerned, the High Courts are courts of record set up under Article 215 of the Constitution of India. Article 215 of the Constitution of India reads as under High Courts to be courts of record. Every High Court shall have a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. It is clear that these constitutional courts, being courts of record, the jurisdiction to recall its own order is inherent by virtue of the fact that they are superior courts of record. This has been recognized in several of our judgments. The judgments are cited. So if Lordship feels that there is an error, Lordship has the ample power under Article 215 to rectify. Then under 226, I have two judgments, 2014 14 SCC, page 77, State of Rajasthan versus Surendra Mahnot and another. Paragraph 21 to paragraph 26. Paragraph 21. Let me start from paragraph 20. Having stated so, we shall presently proceed to address whether the writ court was justified in rejecting the application for review. The order of rejection only notices that the order was passed on agreement and therefore it could not be the subject matter of review. The learned single judge, as it appears, did not think it appropriate to appreciate the stand of the state and passed an absolutely laconic order. While dealing with the inherent power of the High Court to review its order under Article 226 of the Constitution, in Shivdev Singh versus State of Punjab, the Constitution Bench observed that nothing in Article 226 of the Constitution precludes a High Court from exercising the power of review, which inherits in every court of plenary jurisdiction to prevent miscarriage of justice or to correct grave and palpable error committed by it. Then there is another case which has been cited, Abhiram Kuleshwar Sharma versus Abhiram Sipal. It's a very old case of 1979. May I read it out? It is true, as observed by the court in Shivdev Singh versus State of Punjab, there is nothing in Article 226 of the Constitution to preclude a High Court from exercising the power of review which inheres in every court of plenary jurisdiction to prevent miscarriage of justice or to correct grave and palpable errors committed by it. But there are definitive limits to the exercise of the power of review. The power of review may be exercised on discovery of new and important matter or evidence which, after due diligence, was not within the knowledge of the person seeking the review or could not be produced by him at the time when the order was made. It may be exercised where some mistake or error apparent on the face of record is found. It may also be exercised on any analogous ground, but it may not be exercised on the ground that the decision was erroneous on merit. That would be the province of the Court of Appeal. A power of review is not to be confused with appellate power, which may enable an appellate court to correct all manners of error committed by the subordinate court. And in the Tungabhadra case, I'm keeping this because this law is more or less in paragraph 26. In the case in hand, on the factual score has uncertain, the application for review did not require a long-drawn process of reasoning. It did not require any advertence of merit, which is in the province of appellate court. Frankly speaking, it was a manifest and palpable error. A wrong authority which has nothing to do with the list was cited and that was considered. An already existing binding precedent was ignored. At a mere glance, it would have been clear that to the report that the decision was rendered on the basis of wrong authority. The error was self-evident. When such an self-evident error comes to the notice of the court and they are not rectified in exercise of review jurisdiction or jurisdiction to recall, which is a facet of plenary jurisdiction of Article 226 of the Constitution, a grave miscarriage of justice occurs.
This judgment he might quote it also.
Definitely quoted, but I am not arguing on merit. I am not arguing on merit. Why the Honorable Court directed that we should frame a policy on the premise that they are still continuing for 10 years and they are in the second decade of working. So this is not on merit. This is a factual incorrect position placed before the court, or the court also understood it that way. So I am not arguing anything on merit. If they are working correctly for 20 years or 10 years and on the date of the judgment, the order, I would not have come before this Honorable Court seeking review. Either I comply it or I file appeal. What we have stated in our affidavit in the review application, that in the process of complying with the order, we find this is the position. The ground reality is totally different. They are not working since 2006 as Shiksha Saroj. All these volunteer teachers, honorary teachers, this has no meaning in service to students. These are not in the scheme of things of the state government or the Sarva Shiksha Abhiyan. And Honorable Court also did not look into those because those were never urged. They have suppressed the material fact. They were trying to give an impression before the court that they are working as Shiksha Saroj in 2017 also. That impression somehow
fructify to this order.
The problem is you did not,
Because that was
you
not,
did not question that.
no, we did not question that. That was not the debated. That it was not debated.
But you could have brought it up.
That is why review. That is why review, Lordship. A new discovery of facts or a fact which was not placed at that relevant point of time, which was very relevant. Therefore, the next judgment which I am going to cite, Lordship. Because on the pretext, on the precondition that they are working, the space policy can be failed. But that is not the correct position. From where we'll collect all these people now? Who will get the benefit? And that was not the intention. The Honorable Court gives the benefit or that relief on the ground that they are still continuing for such a long period of time. In that situation, the Honorable Court was pleased to direct the state government that you frame a policy and give them the benefits of Nihal Singh, Jatik Singh, and the other case, Upen Das case. And we are also willing to do it. In fact, while attempting to implement comply, then only this factual ground realities evolved. It came into light. 2005, 4 SCC, page 741. BCCI versus Netaji Cricket Club. Paragraph 88 onward. I'd like to read 3-4 paragraph, short paragraph.
No, no.
But 741, 2005, volume 4 SCC, 741. Paragraph 88. We are furthermore of the opinion that the jurisdiction of the High Court in entertaining a review application cannot be said to be expressly bad in law. Section 114 of the Code empowers a court to review its order if the conditions precedents laid down therein are satisfied. The substantive provisions of law does not prescribe any limitation on the power of the court except those which are expressly provided in section 114 of the Code, in terms whereof it is empowered to make such order as it thinks fit. Order 47, Rule 1 of the Code provides for filing an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence, or when there exists an error apparent in the face of record, but also if the same is necessitated on account of some mistake or on any other sufficient reason. Thus, a mistake on the part of the court, which would include a mistake in the nature of the undertaking, may also call for a review of the order. An application for review would also be maintainable if there exists sufficient reasons thereof. What would constitute sufficient reason would depend upon the facts and circumstances of the case. The word sufficient reason in Order 47, Rule 1 of the Code are wide enough to include misconception of fact. This is what I am trying to emphasize. Misconception, maybe with the advocate, maybe with the Honorable Court, or law, by the court or even an advocate. An application for review may be necessitated by way of invoking the doctrine of actus curiae nobis gravati. Then 2 judgments were quoted.
Basilica Catholic, and Lily Thomas again, paragraph 91, 92. I'm coming to 93. It is also not on record, it is also not correct to contend that the court, while exercising its review jurisdiction in any situation whatsoever, cannot take into consideration a subsequent event. Here, the opinion expressed by the 9 officers of the department of Kamrup district. That is a subsequent development because we did the inquiry and we found that they are not in service.
What is the date of that, those,
Yes, 19th, paragraph 9. Paragraph 9 of our review, we have given the date.
23,
Sorry.
it was not there, then it is 23.
In the pleadings, we have given the date.
2023, 23 2009.
23, 2019, and judgment was 2017. We have very categorically stated that in the process of complying of the High Court's order, then we did the inquiry because we have to know the exact number of persons for whom the policy is to be framed. That line also we have stated in our review application. In the process of complying.
Okay, but that document was of 2020,
Yes, 2020.
2020. And what does it say, that the document, what does it say, that
They are not, no one is working there.
but they are not working as on which date?
Because according to them, they are still working. So what they have said, I do have a confirm that no Shiksha Sarathi is working in the school under my jurisdiction. So at present, no Shiksha
So
Sarathi,
as on 2020, they were not working.
they were not working.
But how do we know if they were
How
not
do
working?
you know? Because if we look at my Lord Justice Gogoi's judgment in 2005, which also we have placed now. In 2005, this honorable court did not allow them to continue any further. The MD before the honorable court said that we are not going to extend it. Whoever is working, there is a live contract agreement. The date is still there. They will continue, but no further extension. That judgment also we have placed here at page 50. This is an important piece of document which you will find out later. This was never placed before the honorable court. 17/5/2005 order. This is also a part of the review application. The petitioner second paragraph I am reading for. The petitioners who were 55 in number were appointed as Shiksha Sarathi for the period of 11 months, which has expired. The relief prayed for in the writ petition is for a direction for consideration of their cases for extension of their service up to the year 2010, till which year Sarva Shiksha Abhijan mission is to continue. In support of the relief prayed for, reliance has been placed on the Learned Council for the petitioners on an order passed by this court in similar matter, which is registered and numbered as WPC so and so. A copy of the order dated 38/2005 passed by this court in the aforesaid proceedings have been enclosed to the writ petition. The same has been duly perused to ascertain as to why Shiksha Sarathis are being appointed for 11 months and whether the court should pass an order for extension of their service on expiry of their contractual appointment, and as instructions were not forthcoming from the Learned Standing Council, this court had required the mission director to be personally present. He is accordingly present today. At the hearing, Sri Tiwari, the mission director, had submitted that Shiksha Sarathis are the second teachers provided to LP school, which schools by virtue of their student-teacher ratio is entitled to have a second teacher. Sri Tiwari has further submitted that scheme of appointment of Shiksha Sarathis and making provisions for a second teacher in the LP school under the Sarva Shiksha Abhijan mission has been discontinued pursuant to a policy decision of the Government of India and a parallel commitment received from the state for appointment of regular second teachers in such LP schools. Sri Tiwari has very categorically stated before the court that scheme of appointment of Shiksha Sarathis have been discontinued, already discontinued. And by and large, no Shiksha Sarathis being in service at present, except a few cases where the period of contractual period is yet to be over. This court finds no apparent justification for following the earlier orders passed by this court in a connected proceeding. The plea of discrimination advanced by Sri Molla, learned counsel for the petitioner, does not find acceptance of the court in as much as in view of the stand now taken by the mission director personally present. The orders passed in the proceedings earlier cannot form the basis for continuation of such orders in this proceeding. In the light of aforesaid discussion and for the reasons recorded, I find no justification to continue to entertain this petition. The writ petition is accordingly dismissed, no cause. So, my humble submission is that it was known to the Honorable Court in 2005 itself that Shiksha Sarathis are no more continuing. And in our pleadings also, we have said the last date of Shiksha Sarathis working was 1/6/2006, when all the contracts were expired or it was over. So, this is a subsequent development that finding that they are not working. So when they say they are not working in 2020, the obvious corollary is that in 2007 also they were not working, because our stand before this honorable court was very clear in 2005 itself. So that being the
That order was not brought to the notice of the.
absolutely got it. That is another ground of review. This was also brought to in the review application. So this is an important piece of evidence or discovery of this order. It was in existence, but it was not known to the council or the department. But finally, while trying to formulate the policy, all this happened because the government had the intention to comply with the honorable court order. It was a full bench order. So we did not have the intention of going to file SLP. We wanted to follow it. Ultimately, Lordship, we backtracked because we found that they are not working for 15 years. In fact, it is a case of perjury for them. So this judgment is their Lordship. Then another judgment, 2009. Which is 2009, 14 FCC, page 663, Inderchand Jain versus Motilal. Both expired when the case was decided. So relevant paragraph 33 to 36. Paragraph 8. An application for review would lie inter alia when the order suffers from an error apparent on the face of the record, and permitting the same to continue would lead to failure of justice. In Rajendra Kumar versus Rambhai, this court held the limitation on exercise of the power of review are well settled. The first and foremost requirement of entertaining a review petition is that the order review of which is sought suffers from any error apparent on the face of the order, and permitting the order to stand will lead to failure of justice. In the absence of any such error, finality attached to the judgment order cannot be disturbed. The power of review can also be exercised by the court in the event of discovery of new and important matter or evidence which takes place, which despite exercise of due diligence was not within the knowledge of the applicant or could not be produced by him at the time when the order was made, so that judgment may not be to the knowledge of the standing counsel who appeared before the full bench on that day. An application for review would also lie if the order has been passed on account of some mistake. Furthermore, an application for review shall also lie for any other sufficient reason. It is beyond any doubt or dispute that the review court does not sit in appeal over its own order. Rehearing of the matter is impermissible in law. It constitutes an exception to the general rule that once a judgment is signed or pronounced, it should not be altered. It is also tried that exercise of inherent jurisdiction is not invoked for reviewing any order. Review is not an appeal in disguise. So the law is well settled here also. And another proposition. So these are the judgments I am relying, Lordship. So my case is plain and simple. Two facts were not placed, or it was not to the knowledge of the state authorities, Lordship, during the time of hearing. One is that the judgment of 2005, which did not allow or which did not direct the state authorities to extend the services of the six authorities beyond the contractual period. And number two, although it was accepted from the judgment, it appears in paragraph 42 that they are working for a decade and they are in the service for the second decade. That was not a correct thing. That was actually not correct. Now, while trying to comply with the Honorable Court's order and to try to start the process of formulating a policy in terms of the operative part of the judgment project, we found out that they are not working. And when we filed a review application to the counter, they produced some documents which has fortified our case. Now it is undisputed that they were not working. Earlier it was our finding that they are not working. These 5-6 certificates which they have produced before this Honorable Court today amply prove that they are not in service from 2006 onward. They may be working as honorary teacher, they may be working as voluntary, or they may be working as persons who want to dedicate their life for the students. Those things will not help them in getting the policy formula. So in that view of the matter, this is a fit case for review, so that this whole issue comes to a true purpose. Otherwise, there is no scope for us to start framing a policy when there is no persons who will get benefit. This is my humble suggestion.
One aspect you had said earlier regarding the Right to Education Act, you were saying something.
Yes, because there 2009 Right to Education Act, in that case, in that act, there are certain parameters, the number of teachers to be present. There is no scope for Shiksha Sarogi or Shiksha Mitra in that. That act I have referred from the from the perspective that they cannot continue beyond 2009. Although the ground reality is from 1/6/2006, they are not working. Even let us assume that they are working, but once the act comes into force, we have to fulfill the pupil teachers ratio in terms of the chart given in that particular act. That way also they cannot continue beyond after enforcement of that new legislation of the central government. So all these facts brings us to the single conclusion that they are not working as on the date of the delivery of judgment. In fact, they were not working for previous 10 years. And we have preferred this review application because the order is not implementable. And the intention of the Honorable Court to give them relief on the basis that they are continuing is not, it was not actually in existence. So they do not deserve undue advantage of the kindness of this Honorable Court. they were given equitable relief, but whether that equitable relief they are entitled to or not. In fact, in my humble opinion, they are not, because they should have very firmly come before this honorable court with a statement that our job was over in 2006. Now this certificate, if we go and ask this headmaster notice, lot of things will come out. Whole Pandora's box will come out. These are all manufactured documents. Whoever has a good connection with the headmaster, he is issuing this certificate. On what basis he can issue this certificate? We are not going to that stage now. They will be all in trouble. How can a government school have volunteer teachers? How can a school have honorary teachers when this honorable court in 1994-95 barred all these kind of appointments? Honorary teachers. Lordship knows in 1993-94 regular cases of this honorable court that no honorary teacher can be accommodated in a school, in government. So we are not going to that case, Lordship. My humble submission is Lordship may be pleased to correct the judgment which was delivered by the earlier court. This is my humble submission.
No, you have. Here, so like here,
Lordship.
here, better argument. Little notes. Have you referred to the explanation for delay? Have you covered that part?
Okay, but in the written arguments, we have not brought it delay part.
What is the stand on this delay?
In our additional affidavit, we have explained our delay part. But in the written arguments, we have not. Paragraph 3, 4, and 5 of our review application. And in our written submission in page 2, Lordship may kindly read. After pronouncement of the said judgment, have brought. Second, that's page 2, third paragraph.
Affidavit for review.
No. Lordship will take, would be pleased to take my written submission today.
Yes.
After pronouncement of the said judgment, the government in the education department took up the matter for complying the directions contained in the said judgment dated 26/10/2017, and accordingly reports from the SSS as regard working status of the Shiksha authorities were sought by letter dated 22/11/2017, immediately. Lord. On receipt of the report, it has come to the notice of the state respondents that the contract period for the Shiksha were expired after completion of the initial 11 months, and none of those contracts were renewed thereafter. All these Shiksha authorities were released latest by 1/6/2006. At this stage, it is pertinent to mention that after expiry of the initial, so here there is no explanation of delay, but we have stated here, paragraph 2, 3, and 4 of the review application. Paragraph 3. The judgment and order under review was passed on 26/10/2017 in WPC so upon receipt of the said order dated 26/10/2017, the director in elementary education on 3/11/2017 forwarded a copy of the order to the mission director SSA for information and necessary action. Thereafter, on 22/11/2017, The mission director was again requested to examine the matter in the light of directions passed by this honorable court by taking into consideration background of the engaged Shiksha Sharat case, letters of 22/11/2017. Pursuant thereto, the file was processed in the department and the MD SSA on 26/11/2018. Submitted list of Shiksha Sarathis 1 and Shiksha Sarathis 2, along with note of PK Tiwari, IAS, ex-MD SSA. From the said note, it appears that a total number of so-and-so of SS1 were engaged in single teacher LP for 2004-5 and were released after completion. Similarly, a total of 463 number of SS2 were engaged. The state engagement process was started in so-and-so and was released on 1/6/2006. So 2 years, we are doing all this exercise, 2017, 2018. Hereafter, the list of SS1 and SS2 submitted by MD SSA was examined in detail, and it has been found that some relevant information were missing in respect of some districts like Kachar, Dhubri, Dibrugarh, Goalpara, Golaghat, Hailakandi, Kamrup, Lakhimpur, and Morigaon. Accordingly, MD SSA by letter dated 14/12/2018 requested to furnish the missing information in respect of the aforesaid district. Since no response was received from MD SSA, a reminder was sent on 29 December 2018 was issued. Thereafter, a meeting was held in the month of 2019 for adoption of policy as directed by the Honorable Court in case of Shiksha Sarathi. So in 2019, we are still continuing. In the said meeting, it was decided that to adopt a policy for engagement of Shiksha Sarathi in the same line of policy already adopted in case of Sahiyogi Shiksha Karmi. Accordingly, decision was taken to hold special test of the Shiksha Sarathis who have completed 10 years of service, and the candidates must have all requisite qualifications as per latest NCTE norms. So now this meeting was held on in the month of January 2019. Thereafter, at this stage, it is pertinent to mention herein that while steps have been taken to implement the aforesaid policy formulated to engage Shiksha Sarathis, it has come to the notice of the department that none of the Shiksha Sarathis has completed 10 years of service, which is mandatory condition observed by this honorable court, and hence the state policy could not be implemented. Under such circumstances, the government of Assam in the Education Elementary Department issued an order on 24/7/2019 rejecting the claims of the Shiksha Sarathi. This honorable court directed us to frame the policy on the simple ground that they are continuing for more than 10 years. That is the Uma Devi's mandate, followed by various other judgments, including Nihal Singh. And in respect of all other workers, master roll workers, in Upenda's case, their prayer was for regularization. It is not possible under existing law as on date. So we considered before the court that they will be continuing till 60 years of service, and they will be getting minimum pay scale, and they will get some benefits at the time of retirement. They wanted that benefit here. Their case is that they are working for 10 years, much more than 10 years. Now, here we have found during this time, the department that none of the Shiksha Sarathi has completed 10 years of service. So it was found in July 2019 at the final stage of formulation of the policy. Then we came and filed this review application. This review application was filed in 2019 itself. We have filed it. It is not that it was filed later. It is the file. So in July, 24th July 2019, we came to know that they are not working for 10 years. Within 10 days, we filed the review application. On third day, 27/8, within 1 month. So in my humble submission, Lordship, there was no apparent delay. At the last stage, last hurdle was that whether they are working for 10 years or not. Therefore, paragraph 42 is very crucial. The Honorable Court, that is why we use the word decade, and in the second decade, because that carries the importance of 10 years of service. So in that view of the matter, Lordship, whatever they are getting, those benefits given to them, Lordship, they are not entitled. If they can prove that they are still working as Sixta Circle Lordship, definitely my review application deserves to be taken. Highly obliged.
Today in 5 minutes, but I cannot. Today in 5 minutes, perhaps I cannot complete. Today is the reference.
Okay.
I'll refer at half an hour.
I thought they were going to finish it in 5 minutes actually.
No, actually, I can, but my lord, my learned friend has referred to so many times. I'll have to deal with. By the way, my lord, in contempt proceeding, contempt was initiated on 7/8/2019. Thereafter, this contempt was initiated. Initially, notice was issued. They paid no heed. When contempt was initiated on 7/8/29, his review petition filed.
Contempt initiated
On 7/8/29. 20.
7, 8, 19.
Yes. Then on 27/8, they filed the review.
7. So, thank you. This matter was not, the direction was not given at the motion stage. It did continue for 5 weeks. The fact that you are trying to impress upon that they are not working, we may not have much difficulty or dispute with them, whether they are working or not working. They may not be working. But this fact of not working is not a fact which you had come to know after the judgment. That was the court issue which you had defended.
In that, yes, not the main point.
See, you may contend that you are not aware of a court order. This is possible. You may not be aware that there was an act of 2009 which prohibits continuation of Karate. But the fact that these persons were not working or there in service is the basic defense which you should have pointed out to the court.
Actually,
It is not because that they are trying to implement some third party, etc. No, they are not working. This is the main defense.
because this was, in fact, what we should have done in the case of res judicata. Similarly situated persons, they face the dismissal order. Because similarly situated persons filed another writ appeal, and that was dismissed. That judgment was relied upon. Then only it came before the full bench. If full bench did not allow us to file affidavit, if the affidavit was required at that point of time, we are little bit easy because similarly situated persons face the fate of dismissal in identically placed cases.
Those similarly situated persons are of conduct district or other.
Maybe let me check it because we have that judgment. Other Shiksha Sarathis, they face the dismissal before the learned single judge as well as before the division bench.
Yes. Division bench of Justice Goyal. Division bench of Justice Goyal.
Yes. The division bench order was of my Lord Justice Goyal and my Lord Justice Koteswar 3/8/2012. Page, this is writ appeal 222/2012. Dismiss. Yes, dismissal order. Every time what is their case? They want regularization. Triple two, the WA 222 of the 2012. It is annexed, it is page 304, it is annexed, part of the record.
What is the single bench order, WPC number? WPC 3743 of 2011. That was dismissed. 3743 of 2011 by order dated 7/2/2012. 7/2/2012. After WA and 8/2, no, WA number. What is the WA number?
WA 222 oblique 2012.
222 of 2012. Dismissed on 3/8/2010. Then thereafter it went to another single bench. Correct.
Yes, Lord.
What was that? What was that single bench case number?
Yeah, different. Okay.
There was a single bench. The single bench had referred the matter for prosecution of another division bench. Okay, anyway, that's the next day. No time. Just thinking that since holidays are coming up, we could have done something. Anyway,
If there is a gap, the only problem is that I also forget Lord. The whole, we have to start afresh. One thing is very clear. In all the cases, they want regulation. And the Honorable Division Bench, full bench also did not grant them that relief. They have molded the relief. That is why this aspect of 10 years service become very relevant. Otherwise, it was not relevant.
In my lord, it was never our case that we have filed for more than 10 years. The amendments are very clear. We say 7, 8. It's there.
so the problem is when disposing of the matter, this court had held that the full court had held that it appears that they are in the second decade.
Second.
of employment.
Second decade in a different sense. When
Okay,
I'll place the facts, my lord, in
Ah.
create a plausible guess.
right. Heard Mr. Counsel for the review petition and Mr. K. Chaudhary, the senior counsel for the respondent. This the matter when
My lord, first week of May.
we are to the date. Preferably on a Tuesday.
6th of May.
6th of May.
Kumpat.
Tuesday, okay. No, 6th of May is a Monday,
Monday,
not a Monday. No.
then 7th of May. Oh,
Oh,
7th,
thank you.
Guwahati is the election.
Oh, you're in there, you must
My,
be very
he
busy.
may be busy, Lord. My learned senior.
My lord, normally he is more busy in election
Yes, yes.
times than me.
6, 7,
Though I'm involved in a political party.
No, he may
Normally
contest.
my learned friend is much more busy.
I am busy, but he may contest, Lord.
So my time of contest is over now.
You're in a political party.
Of course.
Vice president also.
I am a vice president of a regional political party of this state.
Okay. Right. You'll give a date, please.
9.
It's a matter on night. At 2 p.m.
Lordship, 9 will be, yes, Lordship, 9. Lordship.
At 2 p.m.
Yes, Lordship.
Even half an hour time, we can do at 2 p.m. That will be good. Yeah, he can also reply. Yes.
That refreshing.
अच्छा राइट मिस्टर बी साइकिल तो एडवोकेट So you have relied only upon six judgments.
Yes.
Please take a.
Only six, my lord. Only six.
Only six.
He would have been sufficient. Because second judgment, because the earlier judgment very old. That's why the new judgments also relied upon the same.
You want this back? I'll just type it.
You know why old are better.
Older, better. Very elaborately
You will find a judgment in 1962, authored by I think Justice Banchu and Justice Gajendra Gadkar. They have refused initially to condone even a day's delay. 1 day delay.